Good afternoon. I'm Linda Hobgood, and on behalf of the Speech Center at the University of Richmond, I would like to welcome you to the 2010 Orator in Residence Luncheon. I'd like to invite University Chaplain, the Reverend Craig Coker, to offer a blessing over our meal.
Let us pray. Gracious God, in the beginning you spoke words, and creation came into being, and you called it good. Through your prophets you spoke words of justice and words of hope for all your people. Through sacred scripture you speak words of poetry, prayer, and comfort. Continue to speak, O God of words, through the voices of your children across the world, in the quiet of our own hearts, in the conversations around each table, and in the food we now share. Amen. Please enjoy your meal.
Ladies and gentlemen, good afternoon. Welcome to the University of Richmond. Isn't this a great day? I'm Steve Allred, Provost here at the University of Richmond. I'm delighted to welcome you on behalf of our President, Ed Ayers, who, appropriately enough, although he wishes he could be here, is speaking at a conference in Gettysburg today. So, as a historian of the Civil War, I'm sure you can appreciate his need to be there. We're delighted to have all of you here. I know we have folks from the community, we have students, we have faculty and staff, and we are just delighted to have all of you here for this great occasion. It is my honor this afternoon to introduce Judge Henry E. Hudson, who will in turn introduce Justice Scalia. Let me give you a brief introduction about Henry Hudson, who is a native Virginian. He was appointed in 2002 by President George W. Bush as United States District Judge for the Eastern District of Virginia. He graduated from Wakefield High School in Arlington, Virginia, received both his undergraduate and law degree from American University. Judge Hudson has served in a number of public service capacities: Deputy Sheriff, a Deputy Clerk of Court, an Assistant Commonwealth's Attorney of Arlington County, and later as Assistant United States Attorney for the Eastern District of Virginia. In 1979, Judge Hudson was elected Commonwealth's Attorney for Arlington County. He was re-elected to that post in 1983. President Ronald Reagan appointed him United States Attorney for the Eastern District of Virginia in 1986. Following a stint in private practice with Reed Smith, Judge Hudson served as Circuit Court Judge for Fairfax County from 1998 to 2002. And subsequently, President George H.W. Bush appointed Judge Hudson as the Director of the United States Marshal Service. While in private practice, Judge Hudson hosted America Under Siege, which was a weekly talk radio program on WWRC. He also chaired the Virginia Criminal Justice Services Board. He provided regular legal commentary for Fox News, CNN, and Court TV, and he also served as a consultant to Paramount Pictures Incorporated. He is currently serving in another distinguished role, adjunct professor at the University of Richmond School of Law. We are delighted to claim him. And he is author of Quest for Justice. Ladies and gentlemen, please join me in welcoming Judge Hudson.
Thank you, Steve, for that very generous introduction. You all have heard the expression, your speaker needs no introduction. Well, that's the case here today, but I'll do my best. A few weeks ago, one of Justice Scalia's colleagues told me that one thing that every member of the Supreme Court agrees upon is that the justice has the most eloquent pen on the court since Judge Robert Jackson. Antonin Scalia is the 103rd Justice of the United States Supreme Court. He was sworn in on September the 26th, 1986. He's a graduate of Georgetown University and Harvard Law School. He practiced law for a while with Jones Day. He served as general counsel in the Office of Telecommunications Policy in the Executive Office of the President. He taught constitutional and administrative law at the University of Virginia, University of Chicago, Georgetown University, and Stanford University. In 1974, he was appointed by the President as an Assistant Attorney General of the United States for the Office of Legal Counsel, which, having worked in DOJ, I'll tell you, that's one of the most prestigious posts in the Department of Justice. Now, immediately before his appointment to the United States Supreme Court, he was a judge on the U.S. Court of Appeals for the District of Columbia. He's the author of two popular books, A Matter of Interpretation, Federal Courts and the Law, and Making Your Case, The Art of Persuading Judges. Ladies and gentlemen, it's my great pleasure to introduce to you Justice Antonin Scalia.
Thank you very much. Thank you very much, Henry. What you didn't hear in Judge Hudson's bio is that he is an avid and very good hunter, and most of my time with Henry has been spent in that endeavor. And I have to say that Fairfax's loss is Richmond's gain. We miss him up there. He's been down here, 5 years or so now? How long is it?
10.
Almost 10. God. Well, I have to tell you, it is intimidating to be billed as the orator in residence. I've been down on the Potomac with pebbles in my mouth for the last couple of weeks, a la Demosthenes. The subject of my remarks has been billed, I think it's been billed somewhere, as "Do Words Matter?" In the Western tradition, words have mattered a lot. The Gospel of St. John begins that way. It equates the Word with God. In the beginning was the Word, and the Word was with God, and the Word was God. Words were something very, almost sacred. I intend to speak about words in the context of the law, but what I have to say about what has happened in the law applies in other fields as well. That is to say, a denigration of the word, so that words don't mean what they meant, but rather mean whatever someone wants to bring to them. In the field of literature, this is called deconstruction. Passages don't really mean anything. They're just an invitation for the reader to put into the passage what the reader would like. The same phenomenon exists in scriptural interpretation. Indeed, the word exegesis, which is what it used to be called, has now been, if not replaced, at least accompanied by what is called eisegesis. That is, reading into the sacred text what you think it ought to say. I want to speak about this same phenomenon in the field of law. It's especially important in the field of, if there's any place where the word has to be important, where the word has to matter, it is in the field of law, at least in the field of law in a democracy. You realize it's quite impossible to have democratic government of any size, in a community of any size, without the written word. You couldn't possibly run a system of democracy in a country that did not have a written language. So it behooves us, as a country that does have a written language, to give the words the meaning that the people gave them. That is, either the people themselves, if they voted directly on the piece of legislation, or the Constitution, or else the words adopted by the people's representatives in a legislature. Unless those words have meaning, and unless judges give them their fair meaning, democracy doesn't work. You end up having what you might call an aristocracy. The words mean what the judges want them to mean. Now, there are three ways, it seems to me, in which words can be twisted so as to mean something different from what they meant when they were promulgated. First of all, and I confess I can't think of an example of this in the law, it is possible that words over time change their meaning. And I suppose a court could give the word its new meaning rather than the meaning that it had when the people adopted it or when the people's representatives adopted it. I wrote this book that was mentioned with Brian Garner, he can only be accurately described as a word freak. He is the editor of Black's Law Dictionary, has written numerous books on legal usage, and he just loves words. He told me on one occasion, he gave me on one occasion an example of a word changing its meaning. He asked me, what does the word Nimrod mean? I know what the word Nimrod means. Nimrod was a character in the Old Testament. He was a great hunter. And to call someone a Nimrod meant that, this was a hunter. He said, no. He said, it means an idiot. I said, that can't be. So I asked my law clerks, what does Nimrod mean? They say it means an idiot. And you know how that came about? It came about because of Bugs Bunny. Elmer Fudd. Bugs Bunny kept on calling Elmer Fudd a Nimrod because he was a hunter. Kill the Wesley Wabbit. He had the blunderbuss and he was a fool. And there's so many people who have read or have watched Bugs Bunny but never read the Old Testament that Nimrod now means an idiot. I have been trying to think of an example where that has happened with regard to statutory or constitutional interpretation. I frankly can't think of one. Maybe I don't know. Has establishment changed its meaning so that, the prohibition of an establishment of religion, does establishment mean something? No, I don't think it means anything there. Anyway, if somebody can think of an example of that, I'd love it because it would complete this talk. The second manner in which words can be given a meaning that the people didn't really agree to is by simply taking them to mean something that they cannot possibly mean, giving the words a meaning they simply do not bear. And I have lots of examples of that, both in statutes and in constitutional interpretation. For example, you remember all the hullabaloo about the spotted owl out west, and huge tracts of forest were set aside from lumbering because it would endanger the habitat of the spotted owl, or the snail darter, or the kangaroo rat, or all of these endangered species. That prohibition of destroying the habitat of endangered species is an interpretation of a statute, the Endangered Species Act, which forbids the taking of any endangered species. Henry Hudson and I know what taking an animal means. It's a hunter's term. It means killing or capturing or wounding, bringing into subjection. But it was interpreted by the agency, and the courts affirmed the interpretation to mean endangering it by destroying its habitat. I don't think the Congress would ever have voted for a provision that extreme that said, if you find a kangaroo rat on your farm, you can no longer farm. I doubt whether Congress would ever have voted for that. That's one example. Another one is a case we had several years ago. I'm not sure, Kevin was my law clerk at the time, involving the Clean Water Act, in which the court held that the crucial term waters of the United States, that was the area over which the agency had jurisdiction, included a plot of land that was marshy and that the owner tried to drain into the gutter along the side of the street, the gutter which was dry, but any water in it would eventually run down into a stream, and his land was part of the waters of the United States. I think that's just an interpretation the word simply doesn't bear. But that's nothing new. We've been doing that for a long time. Under the Constitution has a provision in it that requires fugitives from justice to be turned over to the state from which they are fugitive by the executive of the other state. And those of you who are old enough, remember that there are always been cases where the governor of one state simply refuses to extradite somebody to another state, even though the Constitution says in clear words that fugitives shall be turned over by the chief executive. Well, we held in a case, it says shall be. We held that those words were just precatory. Unlike the rest of the Constitution, that was an invitation and not a command. We probably did it because we thought we had no means of enforcing it if we had held to the contrary. What are we going to do, send the army? Anyway, that's just giving the word a meaning it simply did not bear. The Due Process Clause of the 14th Amendment, which provides that no person shall be deprived of life, liberty, or property without due process of law. It's obviously a procedural guarantee. Can you be deprived of life? Yes, you can be condemned to death, but not without due process. Can you be deprived of liberty? Yes, you can be sent to jail, but not without due process. Can you be deprived of property? Yes, you can be fined, but not without. It's a procedural guarantee. But my court has held, and I guess the first case that really applied the doctrine was Dred Scott, not a good lineage. My court has held that some liberties are so important that no process will suffice to take them away. What liberties are they? I will tell you. Just ask us. The ones we like are, the ones we don't like aren't. But you realize that converted what was a procedural guarantee, a guarantee of process, into a guarantee of substance. You cannot take away certain liberties. That was never written into the Constitution. We made it up. Or take the Cruel and Unusual Punishments Clause. the Eighth Amendment. It had never been thought that when a sadistic prison guard beats up on an inmate, that that's a punishment. I mean, a punishment meant something to which the defendant had been condemned after trial. That punishment could not be cruel and unusual. If you have a sadistic prison guard, your remedy was not the Eighth Amendment, it was state tort law. Nonetheless, my court has held that any cruelty while you are in prison, even though you haven't been condemned to it, is covered by the Cruel and Unusual Punishments Clause. Now, I really don't think the text bears that meaning. That's not the punishment to which the inmate has been condemned. And finally, although I could probably come up with other examples, take the Fourth Amendment, which says that no person shall be, that a persons, houses, papers, and effects cannot be subjected to unreasonable searches and seizures. Persons, houses, papers, and effects. The first time wiretapping came before my court, the court held quite correctly that wiretapping did not violate the Constitution. A conversation is not persons, houses, papers, or effects. I guess it was 20 years later, the court reversed itself and said that a telephone conversation is indeed covered by the Fourth Amendment. I don't think the words bear that meaning. How can you possibly get that out of persons, houses, papers, and effects? But that's where we are. So those are two of the three ways. The third way, and the most common one, and the one that I think is most eroding our law nowadays, the most common way of twisting words, is to give a vague or general term a meaning that it was not understood to have by the legislature or by the people who adopted it. For example, the Cruel and Unusual Punishments Clause. A general term, and it was meant to be a general term because it had to cover punishments in the future that weren't envisioned, that some crazy man would invent. Nonetheless, I have sat with 4 colleagues, they're all off the court now, if not off the planet, who believed that the Cruel and Unusual Punishments Clause forbade the death penalty. No one thought it forbade the death penalty when the people ratified the Eighth. No one thought it. They couldn't possibly have thought that because the death penalty in 1791 was the only penalty for a felony. It was the definition of a felony, a crime punishable by death. It's why we have Western movies, because horse thieving was a felony. And you either hung the horse thief or you let him go. You held him in a jailhouse until the trial was over, after which you hung him or let him. It was very efficient. Or take the word liberty. I've already told you how the Due Process Clause has been distorted so that it's no longer a guarantee of process, but a guarantee of liberty, absolute liberty in some cases. But some of the liberties that the Supreme Court has found to be protected by that word liberty, nobody thought constituted liberty when the 14th Amendment was adopted. Homosexual sodomy was criminal in all the states. Abortion was criminal in all the states. And the court has come close to saying the liberty of taking your own life with the assistance of someone is also a liberty. Nobody ever thought that's what liberty meant. This way of, or lastly, one last example, the phrase, the freedom of speech in the First Amendment. Congress shall make no law abridging the freedom of speech. Nobody ever thought, when the American people ratified that the freedom of speech included the freedom to libel someone, to slander someone, to make untrue statements that were harmful to the reputation of someone. That was an offense that could be sued upon. Nonetheless, in a case many of you are familiar with called New York Times versus Sullivan, the Supreme Court held that the freedom of speech includes the freedom to libel, at least if you're libeling a public figure. So long as the libel is not malicious, you have to prove that you intended to harm the person, which, did not used to be the law. Now, all of these things, I have to give you one more example. And this last example shows you how much the attitude of the American people towards these things has changed. The Equal Protection Clause provides that no person shall be denied the equal protection of the laws. No one ever thought, at the time it was adopted, that this forbade denying the franchise to women. Now, denying the franchise was a very bad idea, but nobody thought that the Equal Protection Clause forbade discrimination in that regard, any more than it forbade discrimination in the franchise on the grounds of literacy or on the grounds of property ownership. All of those things were perfectly accepted in all of the states when the 14th Amendment was adopted. And therefore, when the American people thought that many states had already given the franchise to women, but when the American people thought every state had to do that, they didn't come to the Supreme Court and say, gentlemen, because they were all gentlemen in those days, gentlemen, what could be a greater denial of equal protection in a democracy than denial of the franchise? Right? And you know that if that issue came up today, my court would say, yes, women have the vote, even though equal protection never meant that. But the American people in the 1920s understood our system better. They understood democracy better, and they understood that nobody had ever forbidden the states from making that distinction. Therefore, they did the honest thing. They amended the Constitution to forbid discrimination in the franchise on the basis of sex. But that shows you what a difference there is in the American mentality between 1920 and today. I think anyone would expect the Supreme Court to say, oh yeah, giving equal protection, that general term, the meaning that we would like it to have today, even though it was not the meaning that the American people agreed to. Now, what's the problem? So who cares? Who cares? Why do words matter? Well, of course, the background rule that we live under is democracy. And what democracy means is that the majority rules. Don't talk to me about, insular minorities and all that stuff. I mean, the background rule of democracy is the majority rules. We debate things, we discuss it with each other, we try to persuade each other, but in the last analysis, you put it to a vote directly or through your representatives, and the majority rules. Except in a liberal democracy, which is what we have, the majority doesn't rule about everything, right? We have said the majority will not rule about freedom of speech. It will not rule about religion. It will not rule about allowing unreasonable searches and seizures, and so forth, down the other provisions of the Bill of Rights. Every one of those provisions is a limitation on democracy, right? But who created those limitations? The people. The people themselves imposed those limits upon democracy. And when you allow a court to give words that the people adopted in the past, whatever new meaning the court thinks is a good meaning, you are allowing a very small segment of society, 5 out of 9 hotshot lawyers, to run the country. You are allowing the Supreme Court to limit democracy, which is not the way it should be. Now, this is called, this giving meaning to general terms which they never had in the past. This is called the living Constitution. See, Constitution grows. Oh, yeah, it didn't used to mean that, but it does today. It didn't used to mean you could libel public, but it does today. It didn't used to mean you had a right to abortion, but it does today. One virtue that is usually put forward as the justification for this new system of a living Constitution is flexibility. You'll be told, gee, you know, the Constitution is over 200 years old. The society changes, it grows, and the Constitution it has to grow with the society, or else it will become brittle and, as though it's some kind of I don't know. It's a law, for Pete's sake. It's not a living organism. But if you think that the people who want to give constitutional terms new meaning, which they never had in the past, if you think they're trying to bring you flexibility, think again. You see, my Constitution, the one that the people voted for, provides a very flexible system of government. You like the death penalty? Fine, you can have it. You think it's a very bad idea? Abolish it. Pass a law, persuade your fellow citizens it's a bad idea, and abolish it. And you can change your mind. If you abolish it and you find there's a lot more murders, you can put it back in. That's flexibility. But the people who want to use the Cruel and Unusual Punishments Clause to abolish the death penalty, they want the death penalty to be impossible in any state, at any time, now and forever, or until the Supreme Court changes its mind. That's not flexibility, it's just the opposite. The people who want to use the Constitution for social change are not people who want flexibility. They want what a Constitution will provide and is designed to provide: rigidity. Not change, but impediment to change. And it's the same thing with abortion, the same thing with a lot of other new rights that people want to read into the Constitution. So, for whatever reason you might like the living Constitution, don't think that it provides flexibility. It's just the opposite. For flexibility, all you need is a legislature and a ballot box. That'll change things as fast as you like. Some people also somehow think that this is a conservative liberal fight on the living. The liberals, the living Constitution is good for liberals and it's bad for conservatives. That is not true. It has nothing to do with your social preferences. My court has used the living Constitution to create new rights, but it's also used it to abolish old rights. It reinterpreted the Confrontation Clause to require only, you can bring in hearsay evidence. It just has to be reliable hearsay evidence. That's not what the Confrontation Clause, the Confrontation Clause, for those who are not lawyers. It assures in every criminal trial the accused shall enjoy the right to be confronted with the witnesses against him. It's clear what that used to mean. You had to bring the witness, put him on the stand. But about 25 years ago, my my court held, oh, no, you can have hearsay. You can bring in somebody who says, Joe told me that that's the guy that did it. Did you see? No, I didn't see him, but Joe told me he was the guy that did it. We said that's okay, so long as the hearsay bears, quote, indicia of reliability, whatever that means. You laugh. The district judges who had to apply that didn't laugh. They didn't know what it meant either. Fortunately, we overruled that case and brought the confrontation clause back to its original meaning. The 5-4 majority that overruled it consisted of 2 originalists, me and Clarence, and 3 liberals who were originalists for the day. On the other hand, that was certainly not a conservative opinion. I wrote the opinion. Conservatives are supposed to be I'm a law and order type. Put away the bad guys. But that's what the Constitution said. On the other hand, we had another case entitled BMW versus Gore. It was not Al, it was another Gore. Mr. Gore had bought a Beamer, which is advertised as having this magnificent finish, baked deep in caverns in the Alps by gnomes. And Mr. Gore's Beamer got scratched on the way across the Atlantic. And the company did not send it back to the gnomes to be rebaked. They took a can of spray paint and fixed it up. And he found out about this and was furious, so he brought a lawsuit. And he got his compensatory damages, the difference between the Beamer with and without the scratch, a couple $100. And $2 million in punitive damages against BMW for being nasty. Punitive damages. Which is absurd. And since it's absurd, it must be unconstitutional, right? Anything that's absurd is unconstitutional, under the living Constitution anyway. So he brought suit, and sure enough, my court said, yes, it's unconstitutional. I have no idea what they relied on. The excessive damages clause of the Bill of Rights. And if excessive punitive damages are unconstitutional, I don't know why excessive compensatory damages aren't unconstitutional as well, right? So, and anyway, once again, I dissented in that case, even though if my philosophy were a philosophy that furthers conservatism, I should have been with the majority. We conservatives don't like punitive damages. They're really quite terrible. Unfortunately, the Constitution does not prohibit them. So I dissented, and a pox on both their houses. BMW came out the wrong way, and another case decided the same day. Romer versus Colorado. Romer was, I think, the governor. The people of Colorado had voted in a plebiscite to amend the state constitution in order to forbid according special status against which individuals cannot discriminate. The usual protected statuses are race, religion, disability, what else? Age, sex. And this plebiscite said, you will not add to that sexual preference, which some people thought was stupid, and if it's stupid, it must be unconstitutional. They brought a suit. It comes to my court, and my court says, yes, it's unconstitutional. Relying on, I have no idea, the sexual preference clause of the Bill of Rights. And that one, the liberals liked. They thought that was terrific, and the conservatives thought, they tore their garments. Now, I think both cases were wrong, and a pox on both their houses. The Constitution says what it says, and it doesn't say anything more. Well, do words matter? For a democracy, they matter enormously. Unless we're governed by what the people have agreed to be governed by, we're going to be governed by judges. I think many Americans have understood that that is what has been going on, that under the guise of interpreting the Constitution and under the banner of the living Constitution, judges, especially those of the Supreme Court, now wield an enormous amount of political power because they don't just apply the rules that have been written, but they create new rules. And once that is what the judges do, the selection of judges is no longer a process of picking people who are good lawyers, understand how to interpret a text, have a modicum of judicial demeanor, honest people, all those normal qualities that we used to use for selecting our judges. The new test should be something different. If the most important thing these people are doing, especially at the Supreme Court level, is rewriting the Constitution, giving new meaning to terms that the people never adopted in the past. If that's the main thing they're doing, we ought to be interested, not in all those. It's nice to have good lawyers, but that's not the most important. Most important thing is, will this person write the new Constitution that I like? And so you've seen the confirmation process turn into, really ridiculous. Judge so-and-so, do you think there's a right to this or that? You don't. Well, I think it's there, and my constituents do, and I'm certainly not going to put you on the Supreme Court if you realize how absurd that is? It's like having a mini constitutional convention every time you confirm a new justice. Makes no sense at all. But frankly, I prefer it to the alternative. Because if the Supreme Court is indeed, under the guise of the living Constitution, rewriting the document, giving it a meaning it never bore before, then by George, the Supreme Court ought to be politically accountable. And the only way it currently is through the nomination and confirmation process. I would rather have the people rewrite the Constitution, even in that Byzantine indirect fashion, than have it rewritten by entirely unaccountable judges. So, my answer to the question, do words matter, is yes, words do matter, and more Americans should realize the truth of that. Thank you.
Thank you, Justice Scalia, for those very inspiring and delightful remarks. Thank you for advancing the aim of the Orator in Residence program, which is to demonstrate that hours devoted to the pursuit of articulate public expression will prove time well spent. We would like to thank those who have joined Justice Scalia at the head table today. Richmond alumnus and Speaker of the Virginia House of Delegates, William Howell, and his wife, Ceci. Judge Henry Hudson. The University Provost, Dr. Stephen Allred. Our University Chaplain, the Reverend Craig Coker. University of Richmond Law Professor Kevin Walsh. And representing our students, first-year student, Ms. Nora Ann Miller. We are also happy to have two of our deans present today. Dean of the Jepson School of Leadership Studies, Sandra Pert. And the Robbins School of Business Dean, Nancy Begranoff. I'm grateful, too, for my family who are here almost in toto today, and thank you for coming. The names of those without whom a program such as this would be even possible, even imaginable, are listed in your program, but I would like to thank one individual especially, and that is the administrative coordinator of the Speech Center, Mrs. Linda Caperton. The untold hours that she has spent dedicating herself to the work of the Speech Center and to this event in particular are matched only by her unfailing good nature. And I thank you very, very much, Linda. Thanks is owed to our law school dean, who could not be with us today, Dean John Douglas, who just happened to suggest not too long ago that I pick up a copy of Making Your Case, The Art of Persuading Judges by Antonin Scalia and Brian Garner. That suggestion had so much to do with today's program, and I am very grateful to Dean Douglas for suggesting that I pick up a copy of that book. Copies of Making Your Case and Justice Scalia's earlier text, A Matter of Interpretation, will be on sale in the Ucrops Gallery following the program. Justice Scalia has graciously agreed to a book signing, and he will sign copies following the event. Indeed, words matter, if we ever doubted. They mattered especially to a former student of ours here at Richmond, an Eagle Scout from New Jersey with the most enviable SAT scores. Larry Whitkos enrolled at the University of Richmond as a university scholar in the fall of 1994. Words mattered so much to Larry that he actually began in his spare time compiling a dictionary. He called it an intellectually abridged dictionary. Larry completed the project just, I think, early in his junior year, as he prepared to become a student consultant at the University of Richmond's newly established Speech Center. Then tragedy struck. A persistent pain was diagnosed with pediatric leukemia. Larry proved too young for the adult treatment, but too old for the pediatric treatment. A bone marrow transplant on New Year's Day 1998 brought hope and then despair. Larry lost his battle to leukemia on April 29, 1998, just 2 weeks short of what would have been his commencement, and Larry had been on track to graduate first in his class here at Richmond. In the weeks that followed, his two roommates proposed an idea for a memorial tribute. They suggested reprinting and binding that dictionary. They gave it a name, the Lexicon, and they stipulated that it should be presented on special events and only to people Larry would have admired. Each orator in residence has been a recipient of the Lexicon, and while I think that would have made Larry very happy, those of you who remember Larry would surely agree that nothing quite comes close to this. As I commented to a student just last week, if Larry could have had one day back here at Richmond, this might just have been that day. And so that is why it is such an honor to present a copy of the Lexicon to our 2010 Orator in Residence, United States Supreme Court Justice Antonin Scalia. I want to thank each and every one of you for coming today and for your support of the Orator in Residence program. If you will remain seated while I escort Justice Scalia to the book signing venue, again, thank you for coming and have a wonderful weekend.